Yes.
So then, aren't you playing into their hands if I were to street your argument further?
Your Lordship, if I have to be put to option between the two things, then I believe that we should proceed with the submissions.
We proceed and admit the submissions and hear the matter.
Yes, if it's either of the two,
yes,
then the lesser evil will be to proceed with the submissions.
Okay. What is your view?
My Lord, I join my colleague and I submit, concur with him to the effect that I was also not able to file my submissions because I needed to see what the applicant had filed. But nonetheless, I'll be relying on the grounds of opposition and the replying affidavit from our end. If need be, we can be given leave to file submissions just to address the issues that were raised therein.
And what else?
And replying affidavit.
And further to that, you are saying you'll be asking for time to do what?
To respond to their submissions because, my Lord, we didn't have adequate time. Close of business, 6 p.m. We're not able to file anything.
My Lord, we had filed our submissions on the 19th. It's dated the 19th of June 2026. That was before the applicants filed their submission. My Lord, I have had a chance to peruse the submission.
You said on 19th of May?
June.
Sorry, June?
It's dated the 19th of June.
Yes.
I have had the chance to peruse the applicant's submissions. They are quite bulky and lengthy. And some of the issues that they had addressed, we had not addressed the same in our submissions. So we'll be seeking to respond to some of the issues outside our own submission in today's hearing. We have no objection to the same being admitted.
So, so that I understand you correctly, you're saying we admit them and grant you time to file supplementary submissions?
No, my Lord, and will respond to the same in today's hearing.
We are, however, ready to proceed with the hearing of the matter. Today. Mr. Kinyanjui, so before I get to Mr. Kinyanjui, so as it stands, Mr. Mogere, you are the only one who is not ready.
No, I'm ready. I said I'm ready.
So how do you file submissions after we have already argued the matter?
My Lord, there are issues that I believe are raised there that we won't be able to.
But then if you introduce new matters that the other parties need to respond to, we cannot proceed that way. You'll have to choose either you seek time, I give you time, you file what you need to file so that when we hear the matter, everybody is on the same page.
Then, my Lord, just to save on court's time, I'll be relying on the documents that I have.
Okay.
Yeah.
Yes.
I think the issue is moved because you have said that it's okay.
It's okay, we proceed. So, Mr. Kinyanjui.
Yes, Your Lordship. Once again, I tender my apology. I've explained why it is not within my desire to delay the proceedings. As I've indicated, I had prepared my submissions. However, because of the same petitions, and maybe in the public, really, I'm not trying to invent something which is fictional. And I really apologize because I was a part of it. And I couldn't be able then to avoid. Why? I thought when you gave us this date, those dates had not
much time do you think you will take in your submissions, Mr. Kirungu?
About 20 minutes.
Make it 15. I have made an order that your submissions have been admitted and they are deemed to have been filed within time. So proceed and do your 15 minutes. We now start at 1:50. So you stop at exactly 2:05.
Thank you very much, my lord.
Yes.
Before I commence, I would like to refer you to the amended motion, the judicial review, which was amended on the 29th of April 2026 as a primary document against which to reference my submissions, together with the supporting affidavit of the applicant, sworn on the 24th of April 2026, together with the supplementary affidavit, sworn on the 28th of April 2026, and the second supplementary affidavit, sworn on 30th May 2026.
So the affidavits, one you are saying is dated when? It was when?
24th of April 2026. 24th
26.
of April.
The second one?
28th of April 2026.
April 2026.
And the second supplementary one dated the 13th of May, 1 May 2026.
So you have 3 affidavits.
Yes, my lord, and together with the exhibits next. Before I can commence, my lord, I would like to, with your kind permission, I will abandon the reference to Order 53 of the Civil Procedure Rule, just so that there is no confusion into the importation of the Civil Procedure Rules, but it's a judicial review application in that context.
So you abandon reference to Order 53.
Yes, just so that we do not have confusion.
Okay.
The reference Order 53, but this is a judicial review application, as understood within Article 23(3) of the Constitution. 3(3) Article 23(3). That I have referenced in my submission. Although when you retire, you have a very of it.
Yes.
My lord, I have in my submissions when you retire, and I will make extensive reference to it, to the same submissions. When you do retire, you will see the history, the background of the facts, running from the paragraph number 1 all the way, my lord, up to paragraph number 5.
45,
Paragraph
yes.
number 4. Yes. That gives you the history of the application both for you. Then, my lord, that will make it easier for the court. I did crystallize the issues after looking at the responses by the respondents. We drew the issues which are at page 14 of the application. At paragraph 46, I have crystallized 9 issues.
Page 14 of the application.
Page 14 of the submission. Page 14 of the submissions. At paragraph 46, paragraph 46 captures the issues for adjudication. One of the issues that I will come up because it was raised was whether you have, your lordship, the jurisdiction to engage a judicial review in criminal proceedings such as this to issue the orders that are sought. Now, as I have indicated a moment ago,
Yes.
the background, the Bible, and the springboard of Article 23(3) of the Constitution gives you the constitutional jurisdiction to intervene by way of judicial review. And this, my lord, read together with your supervisory power under Article 165, 6 and 7 of the Constitution over the first and second respondents.
Yes.
My lord, the framework of the Constitution in Article 165, 7 of the Constitution was very emphatic. The jurisdiction is so broad-based, which your lordship considers in the language of, if this is the language of Article 165.7, and I quote, any direction the court considers appropriate to ensure the fair administration of justice. Those are the words used by the framers of the Constitution, so that your lordship at once did not outstar, limit, or otherwise any bar to judicial review orders. Now, when you come to Article 23(3)(f) of the Constitution, you have a similar power where the defense of constitutional rights is engaged. And my lord, I would like to rely on the Supreme Court decision of Communications Commission of Kenya versus Raw Media Services Limited. This is a 2014 EKLR. The Supreme Court decision. Specific reference to paragraph 404 of that decision. I have mentioned that in paragraph 52 of
Sorry, Supreme Court paragraph?
Yes?
The Supreme Court decision paragraph?
404.
Yes.
And my lord, I would like the Defense Commission to quote that because it bears relevance given the binding nature under Article 163.7. That decision is binding of the court under Article 163.7 of the Constitution.
Yes.
And it broadly covers the question of jurisdiction. And I quote, the doctrine of legitimate expectation requires the entrenchment of a duty to act fairly. And in this case, Your Honor, actually, Your Lordship, the applicant is saying that the first and second respondent acted unfairly towards him. Now, he has also invoked Article 47 rights. Now, the Supreme Court went on to say, and I quote again, a breach of Article 47 attracts remedies in judicial review, especially where an aggrieved person has cause to expect that the attendant aspects of fair administrative action would be adhered. It is clear that the essence of Article 47 is to protect a party's legitimate claim of entitlement. That is procedural solidity and not a mere promise of consideration. And this is the emphasis. As such, the court can quash any decision, including in criminal proceedings, arising procedurally or unfairly, but reserves itself no right to engage in the decision duties of the body in question. The court remains the court, and that's the implication that we need. And my lord further relaxes claim on the decision of the Supreme Court in the High Court, Magistrate versus National Police Service Commission. This is a 2016 Kenya Law Report, 1024. I have cited that in...
You said 20 NPS versus NPS?
Yes, versus NPS.
20? 20 what?
2016.
2016.
2000. Yes. KEEFRC. Your Lordship, it is your brother Justice Ongaya, as he then was, did canvass this particular issue and was able to look at the twin issues, the twin approaches of the historical approach of judicial review and now the constitutional order. And I quote what your brother had said. First, the court observes that the applicant is seeking judicial review orders of certiorari mandamus as opposed to the historically irrelevant and related prerogative order. Just like in this case, that the applicant is seeking judicial review orders. We did not invoke the Law Reform Act. We would ground us in the issuance of prerogative order. That's very important, Your Lordship, because your brother went on to find that Article 23, sub-Article 3 of the Constitution.
Yes.
Prerogative orders. That's important.
Sorry?
Because he says, I quote him, needless to state, the current constitutional order does not represent a crown and the related concept of prerogative order.
Yes.
End of quote. responded on the 22nd of January 2026 and rogated upon himself the right to hear and determine this. You are with me, my lord?
Yes, I can hear you very well. I can hear you very well.
Oh, thank you. I'm sorry. It's just that the online image coming across.
Yes.
Therefore, I was about you. My lord, the applicant has complained before you, and it's not attested.
Yes.
That the first respondent did have proceedings that excluded him, even though he's the first accused on the 22nd of January 2026.
On 22nd January 2026, proceedings were conducted in his absence.
In his absence, and he's the first accused in the lower court proceedings. Now, it is imperative to note that your lordship had already intervened in a review application number E145 of 2025, in which your lordship made specific findings that the second respondent hearing, Honorable Alego, had failed to adhere to the right to a fair hearing of the applicant. And you directed your lordship, let the recusal application by the applicant before you as a first accused be heard on merit. Now, what transpired was the second respondent had already been transferred to the the Employment and Labor Relations Court. So she was no longer there. And so on the 21st of January, which is not disputed, 2026, the lower court criminal proceedings were taken before the second interested party, the Honorable Ruth Dombey.
Yes.
Ruth Dombey is the one who then gave directions on the type of proceedings, and you gave a return date of the 26th of March 2026. My lord,
Yes.
there was no jurisdiction there. Or, for the first respondent, Honorable Lucas Bonina, then to take the matter, given that there was a return date, and given that there were orders to type the proceedings, for now the court to decide three things. One, that is Rose Dombey saying. One, how do we move forward in the light that we have now the type proceedings? And for the applicant, we made this plea. We will then be able to know, do we recall any witness? Do we move forward for purposes of Section 200 of the CPC? So all that was supposed to be taking place on the 26th of March. So when now Lucas Onina decides, with respect, Honorable Lucas Onina, on the 22nd of January, to overrule, and that's very important, the order which was given on the 21st of January 2026 before the Honorable Ruth Dombey, you can see all of the rules that are now outside the scope of the law, the Constitution, and the legitimate expectation of the applicant before you. One, why would the Honorable Lucas Onina, aware that the parties had agreed to appear on the 26th of March 2026, act as though he was reviewing, revising, and vacating that order without being moved by anyone? That, my lord, respect, was an error which called for review, because the Honorable Onina could not sit on appeal and hear that or reverse that decision. Secondly,
Just a minute, Mr. Kenyanjui. Now, before you move to your next point,
yes, my lord.
now, Honorable Onina, when he presided over this matter,
Yes.
was that done in open court?
No, your lord. Well, not in the presence, not in the notification of the applicant. Therefore,
Were there
the
actual
applicant
proceedings?
could not have
Were there actual proceedings, to your knowledge? Or it was just a directive that he gave?
It's a directive that he gave. The file was taken to him allegedly because the first interested party, that is the second accused in the lower court, had moved the court to so act, but we were never copied that, and was never heard to him. And you can see why it's important, my lord, just to answer your question.
Yes.
Is that we had appeared the 21st of January. The very previous day, the 22nd of January is a lamentation and accompanied by this applicant before me. And my Lord, the duty of this honorable court is to look into the merit, the propriety of such an order. Was it in order for the exclusion of the applicant before you, being the first accused, directly affected by that order, and in the light of the fact that the Constitution in Article 50 demands that he be present during all the proceedings? My Lord, that is very fundamental. The second issue about the Honorable Lucas Bonina's order is that he had overlooked your own direction. In paragraph 18 of your own decision, in criminal revision number 145 or 25, you had directed that let the applicant be heard on the merits of his application on the 20th of October 2025 in the lower court. Now, why is that relevant? Which brings me to the third point. Section 367 of the Criminal Procedure Code demanded that the lower court satisfy itself as to meeting the terms of your order. That is the law, your lordship.
Section?
Governed by the principal rule of law.
Section?
Under Article 10 2B of the Constitution, you will find, your lordship, that that section was never, ever, to date, being complied with. In other words, you made a review decision in criminal revision 145 of 2025, which today has never been complied with. But you have heard Mr. Mogari telling you that what is outstanding is delivering the judgment. So the question is, even when you return look at those proceedings, pursuant to your power to call and review those proceedings, your lordship, constitutional interest, where is the compliance with section 367 of the CC? My time is out, my lord.
Yes.
If you give me 2 minutes,
Yeah, wind up with the 2 minutes.